June 22nd, 2026. Here we go. Ripping through June. Getting closer and closer to July 4th, 2026. Just another couple weeks. Of course, it wants to give me my notifications. Apparently I'm not the only one that just went live. Oh, how's everybody doing out there? Kathy Watson, good to see you. Wendy, GPC5, Prayer, good to see you. Pink Guns Booty, Radar Star, that's a new one over here on Telegram. Diesel D's, good to see you, brother, man. You been doing all right? Haven't seen much of you lately. Hope everything's going all right for you and your mom. Let's see who's over here on a Munson 58. Good to see you. You're early. Ah, you're driving Diesel D's. And She7. Well, hello there. Out on Rumble. Michael Casper, good to see you, brother. It's going to be some good stuff tonight, folks. Many of you may have already heard, but about the Supreme Court case. It's not the Rahimi case. It's the Hemian case. Hemini case. Anybody else? $777 over here on Telegram. Good to see you. Quantum Kid out on YouTube. Good to see you. Made it tonight. Shaya Shalom. Do I need glasses to see better? No, not yet. Although, it's come to the point where I've had to have some reading glasses to see some of the smaller fine print. And that was about, about 4 or 5 years ago now. On occasion I wear them. I've got different screens that I'm looking at here. I've got 3 different screens, and I'm trying to read. And this part here was highlighted, so, and I didn't know exactly how to pronounce the name. Uh-oh, low volume out on YouTube. It's pretty much peaking out over here, so. Right, because I was squinting a little bit. I'm also noticing a little mark on my face here. Was down on the floor playing with the dog. I'm dog sitting again. Mom's boyfriend went in for surgery this morning. Just a stint. Finally did the other one. 90% blockage in his main artery there. So he ought to be feeling really good after he comes through. But yeah, anyways, we were playing on the floor wrestling him, but I just noticed I had a red mark above my eye. He must have got me. Right now he's laying down over there being a good puppy dog, aren't you, Thomas? Yeah, it's a good boy. Such a good puppy dog. So, yeah. Out on YouTube there, time and Driz. Anyways, if you're having a low volume issue, try to back out and come back in. Yeah, he's 4 years old now, and he's about 110-pound black lab, purebred, just a big old lovable dog. Really fun. Good to see you, Regina. Over here on Telegram. I don't see Mark or Jax or Karen. Hi, Pamela, over there on YouTube. Danny Meyer. Yeah, you know, it's we the people really need to come together and start doing these public corruption complaints. Now, I realize that certain states have not made it online complaints, but you can still file a complaint with the state attorney general per the executive order. Now, here in Idaho, I've made some contact with some people, and we're starting to file public corruption complaints against the sheriff, county prosecutor. So we're going to see what happens here real soon. We're going to start exposing, well, we're already exposing the corruption. Now it's time to start telling on them. Well, I don't even know if I'm pronouncing that right. Cha Ya Shalom. I know Shalom. Peace be with you. Yep. Trump's executive order 14288 instructs the attorney general to investigate. But see, the thing is it's the military that's behind it. The military has been deployed to all the states. Hiya. Gotcha. Okay. I would have never guessed that. So, you know, it doesn't matter. I know. I totally get that that things have been corrupt for a long time. Okay. But things have changed. And, you know, I cannot express this enough. This is a military operation, and pursuant to Executive Order 13818, this is a worldwide revolutionary war. Yep, that's exactly what I was just talking about, Danny, and you beat me to it, brother. Yeah, that's the start of it. December 20th of 2017. So that executive order really is about taking down corrupt governmental regimes worldwide and instituting new government and doing treaties of peace. Okay. Taking down corrupt governmental regimes. Now what's happening? Awesome. Hi, Shalom. Thank you for following since Christopher Hallett. Really missed that, man, because, man, we were right on the cusp of something huge. And, yeah. He's the one that had the evidence of the billing codes on the backside of cases and all the bonds. Yeah. Unfortunately, I did not get access to that information before he was taken from us. Domini Beatty, a declaratory injunctive relief pierces the judge's immunity. Pullum versus Allen, Virginia. Yep. Good old emoluments violations. Sorry to hear that, Cece. Never fun to lose a puppet dog. But they're like family to me. Danny Meyer, executive order doesn't equal law. Now, see, people don't quite comprehend what an executive order is. So, executive, as in commander-in-chief, executive, and an order of the commander-in-chief. That is a military order to execute the law. Not meant to make law, although that is in essence how it's actually been used previously in the past. And that would be, a commander-in-chief's usurpation of power and exceeded their authority to make law. Regina, I'm the one that said that when you file these executive order, public corruption complaints to the Attorney General, that it's the military that's on the backside of that. That's per executive order, sending the military to the states to eradicate all crime. So again, this is a commander-in-chief, a military order to execute the law. Commanding, see, a lot of people do not understand our form of government. Admiralty jurisdiction. Everybody who is a member of the legislative, executive, and judicial branch, you're under admiralty jurisdiction. You're bound to support the Constitution, the supreme law of the land. Article 3, Section 2, that is admiralty and maritime jurisdiction. That is in law. And everybody is under the direct supervision and control of the commander-in-chief. Whether people like that or not, or believe that or not, is irrelevant. That's how our form of government works. Our true Republican form of government. where the executive branch holds that power as commander-in-chief. Hey, good to see you, Doug. Yep, going after the bar, bro? Absolutely. It's going to be exponential here real soon. Man, right, Diesel D's? If Chris was still with us, I guarantee you, somehow, some way, Trump would have had Chris in there working with Doge. Because E-Clause was actually Doge before it was Doge. And yes, it does go to the Attorney General of the state, right? Yep, you're welcome. Oh, they're after you, Wendy. All these tornadoes and storms are starting in, did you say Illinois? Yeah, Illinois. Well, Diesel. So the question is Admiralty jurisdiction the reason their contract with the people requires an oath? No. It's, well, let me think. Well, technically speaking, the contract is the Constitution. Okay? So, as the supreme law of the land, when you get elected, you're bound to support that Constitution, and it puts yourself in law. Law of Nations, Book 1, Chapter 19, subsection 212, about the proper definition of a citizen, is a member of a civil society. So, member of government. Gee, that coincides with Article 6, Clause 3, being a member of the legislative, executive, judicial, both state and federal, who is bound to support, right? So, Law of Nations is a member of a civil society who is bound to perform certain duties and is subject to its authority. Oh, so they're in law and subject to the authority from the Constitution. Hey, Carl, brother, what's happening? Be prepared, a super El Nino is coming. Yeah, we'll see. Yeah. Absolutely, Carl. Gotta have the guns and ammo, water, and yeah, definitely some of those water filters would be nice, right? But food and water, folks. They have those water filter straws that you can pretty much drink any nastiest water. I would highly recommend figuring out a way to at least boil it. But I have water purification tablets, and I mean I've got a canal, irrigation canal out back. I've got a big, huge irrigation canal at the end of the street. and I got the Boise River right down here. So I'm surrounded by at least 3 different sources of running water, which is the preferred place to get water, moving water. Hi, Kim Fry. Good to see you. Hi, Lee. Can I give you some insight on a case, on a private? Absolutely, through Patreon, Tier 4. Fix it fast. There you are, brother. Good to see you. Yep, good old Boise, Idaho. Um, Diesel D's, back to your thing there. It's just a matter of being, bound. It's just like any other contract. You have to perform certain duties, and the terms and conditions of the contract, right, dictate. That's the law. And that's why the Constitution specifically says there shall be no law impairing the obligations of a contract. So, I mean, they're binding themselves to the admiralty jurisdiction when they take their oath. They're agreeing to be governed under admiralty jurisdiction. Now, where the rest of us are governed, supposed to be governed by the common law, the laws of nature. Okay? That's the difference. Hi, Greg. How are you there, Canadian Canuck from the north? Well, I 100% agree, Danny. Again, all political power is inherent in the people. The people are supposed to be the sovereign. Notice it says all political power is inherent in the people. It doesn't say American state national. Nope, nowhere have I found in any of the writings talking about American state national. Nowhere. Anybody provide anything? And I'll give you a hint. The reason why is because the term national as a noun, a political status, didn't exist until 1887. Huh. Is that after the Reconstruction Acts, after they switched us over to Roman civil law, the code, which is the only place you can find it, under Immigration and Nationalities Act? Really? Quite the trickery by Anna von Reitz and anybody else who wants to purport that we should correct our status, become an American state national, because right there in the United States Code, Roman civil law, that's a foreign jurisdiction, that's the law. Show me the law stuff before United States Code. Uh-oh. Mm-hmm. So, what is supposed to be the law? The common law is supposed to be the law. The laws of nature are supposed to be the law. The law of nations is supposed to be the law. That's why it's called the law of nations. or the principles of the laws of nature as applied to the conduct of nations. Wow, that's the full title of the law of nations. But like Bouvet's Law Dictionary 1856 reads under law, civil, that the Roman civil law, the code, is opposed to the laws of nature and the laws of nations and the common law. Oh, that's right. Like Blackstone says, same thing. It's opposed. It's a completely different body of law, of fundamental law. And this is where we have to comprehend and understand that there are three jurisdictions or bodies of law that are referred to as fundamental law. Roman civil law, the code, feudal law, and common law. We're supposed to have common law as our fundamental law, which includes the laws of nature, the law of nations, maxims of law, and our rights as the law, those customs, as Blackstone elucidates in his commentaries, that the common law was actually created by the Saxons, which were the Christian Protestants. Yep. As maxims of law and customs. That's the origin of the common law and what the common law really is. It's not previous decisions of the court, which we've all been told is case law. Well, case law is common law. No, it is not. The saying is that the evidence of the common law may be found in our court's reports. That doesn't mean that every single judicial opinion is common law. Now, as we have read in New York State Rifle Pistol Association versus Bruin case, which they cite from in this case, you'll see they've been slowly building this and taking all this corrupt legislation about the right to keep and bear arms. And what did they cite? Well, Blackstone. Oh, yeah, section 134 there, book 1. Oh, yeah, it comes oh, that would be a primary absolute right. Personal security comes from the laws of nature. Naturally, fundamentally, and principally, we have the right of self-defense. That's what they said in New York Rifle Pistol Association versus Bruin, citing Blackstone's commentaries on the laws of England, section 134, which is in book 1, right there at personal security, going over the rights of the laws of nature. You know, life, liberty, property, those three, or pursuit of happiness. Oh yeah, those primary absolute rights from the laws of nature, those are God-given rights. Those are not constitutional rights. Okay? Okay, so you've heard about the common law is harsh. Absolutely it is. Like, thou shalt not commit murder. An eye for an eye. If you commit a capital crime, you're supposed to be executed. You're supposed to be sentenced to death. Put to death. Period. Now, but equity is another thing. Can I explain equity? Equity is about an equitable interest. And if you read Article 3, Section 2, it says suits in law and equity. So that's in equity. And it refers to land. Having an equitable interest in land. Or have a contract and you have some sort of equitable interest. Equity is equitable. Money, value, property. But, yeah, absolutely, Doug. The law that is common to all is to do no harm. If there's no harm, there's no standing for a cause of action, right? Imagine that. So we're going to be blowing that stuff wide open. In fact, I just was on the phone again today with someone. We're working on public corruption complaints. And I'm like, yeah, look at Idaho Code, Title 19, subsection 504. A complaint is supposed to be laid before a magistrate by a party or the parties under oath. And then the judge says, okay, yes or no. But if he says yes, then he instructs the clerk to file the complaint and send it over to the county prosecutor or city prosecutor, respectively. Well, gee, I don't know. Does that mean that the prosecutor cannot file the complaint? Right. Because the prosecutor cannot swear in under oath and testify to anything, because they have no first-hand knowledge of anything. Yeah, same here in America, Greg. Yeah, the distinctions between suits at law and in equity are hereby abolished, and then they went, oh, there's only one form of action for violation of rights, and that's civil, and then the other action is criminal. No, suits at common law can be criminal or civil in nature. That's all Roman civil law crap. But again, that's all the trickery that's happened, right? All right, so I would venture into this here real quick. We're going to take a look into this case. And there are some very good points made here. And I've seen a few people out there. Oh yeah, so marijuana this. It's not about marijuana. And you know, certain jackwagons out there might actually Jacqueline, there you are. Mark, there you are. Good to see you guys. Right on, Mark. You went riding. Well, me too. I'm going to share that a little bit later, but I'm heading out tomorrow. I need a break. Pretty overwhelmed with my mom's stuff. Just stressed out. Got to go get some downtime. So let's blow this thing up. Now, this is not, technically speaking, is not the official one yet. See, this opinion is subject to formal revision before publication in the United States reports. Readers are requested to notify the reporter of the decision. Supreme Court of the United States, Washington, D.C., of any typographical and other formal errors. Well, I'm going to point one out right now. What was it, page? Yeah, anyways, we'll get there. So this is the syllabus here. Basically breaks down, it's the short version. Okay. Ali Hamani is a dual citizen of the United States and Pakistan. How can you be a dual citizen? According to the immigration test, you have to give up all allegiance. You cannot be a dual citizen. You cannot have allegiance to one nation and then become a citizen of another nation. But anyhow, who was born in Texas. He has spent most of his life living in the Dallas area with his parents and working a stable job. Suspecting Mr. Hamani and his family members of terrorism-related activities, the government conducted a search of the family home in 2022. Throughout the process, Mr. Hamani proved cooperative. He surrendered a gun he kept in the house, pointed agents to some marijuana on the property, and consented to an interview during which he told law enforcement agents that he used marijuana about every other day. More than 6 months after the search, and relying solely on Mr. Hamani's admitted use of marijuana, the government prosecuted Mr. Hamani under 18 U.S.C. 922 G3 for knowingly possessing a gun in his home while being an unlawful user of a controlled substance. Unlawful by who? Where the Fourth Amendment is very clear, the right of the people to be secure. And it's the right of the people, not the right of the American state nationals. And it's most certainly not the right of the citizens. Okay, let's see. And extended the interview, government against him violated the Second Amendment. So he moved to dismiss the indictment, arguing that the government's effort to enforce that section against him violated the Second Amendment. The district court granted the motion, and after an unsuccessful appeal to the Fifth Circuit, the government asked this court to review the case. Oh, you mean the district court actually ruled correctly? See, it says the government asked this court to review. Held. The government's prosecution of Mr. Hemion unlawful user provision is inconsistent with the Second Amendment. That's it. Now, what do they say? The Second Amendment protects the right of all Americans to keep and bear firearms for self-defense. District of Columbia versus Heller. Though, like most individual rights, it has its limits. To determine when the government infringes the Second Amendment, the court begins by asking whether the amendment's term covers the conduct in question. If so, the Constitution presumptively protects it. New York State Rifle and Pistol Association, Inc. versus Bruin. To overcome that presumption, the government bears the burden of showing its regulatory efforts are consistent with the nation's historical tradition of firearm regulation. Oh, regulation? Wait till we get down in here. The government need not point to a historical twin or precise historical precursors. United States versus Rahimi. Internal quotation marks. Instead, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles, like the rule of law, that underpin our regulatory tradition. Oh, wait, what's our regulatory tradition? Uh-oh. What can they regulate again? Uh-oh. This is going to get good, folks. So many people have not thoroughly read this. And the government may reason by analogy, showing that its contemporary regulation is relatively similar to ones well established in the nation's history. See, I'm really starting to see a theme here. We've all been lied to. We've all been taught wrong, even all those who went to law school, all these judges. Everybody's having to relearn the law. And what are they doing? They're going back through the history of law. And they don't care about any statutes or any case law. They're looking for the history of law and applying these fundamental principles of law, the rule of law. And then, two features play a central role in determining whether a modern law is relevantly similar to historical ones. The why and the how. The more closely a contemporary law mirrors a well-established historical analog in purpose and operation, the more likely it is to be upheld. Okay. The government accepts this framework and agrees that 922G3's unlawful user provision burdens conduct presumptively protected by the Second Amendment because the statute bans a class of people, including Mr. Hamani, from possessing essentially any firearm for any purpose. The government construes 922G3 to automatically ban an individual from possessing a gun from the moment he becomes an unlawful user of any controlled substance and remains in effect until he ceases being one. Regardless of what controlled substance an individual uses, in what amounts, whether his drug use has ever made him a danger to himself or others. What? A danger to himself or others? Why he keeps a gun, or how safely he does so. The government analogizes its construction of to what it calls habitual drunkard laws. So they're grasping at straws here, drinking straws no less, which it submits enjoy deep roots in the country's history and are relevantly similar to the regulation it wishes to enforce, citing Bruin. These habitual drunkard laws fall into three general categories. Vagrancy laws that allowed habitual drunkards to be confined in workhouses or jailed. So while confined in a workhouse or jail, obviously you can't have arms. Civil commitment statutes that allowed courts to appoint guardians for habitual drunkards or authorize their commitment to asylums. So in those cases, okay, you're not of sound mind, you got to have a guardian, right? You can't function correctly in society, so you got to have a guardian. And if you can't contain yourself there, then you're supposed to be put into an institution. Okay? And surety laws were under which judicial officers would compel habitual drunkards to post surety bonds to ensure their good behavior. That is what these bonds are supposed to be for. These are not supposed to be appearance bonds. They're supposed to be surety bonds to keep the peace. Oh, dang it. They're exposing the truth here. So those are the three things that they were talking about in reference to the habitual drunkards law statutes. Okay? Has nothing to do with being a user of anything else. But let's continue on here. The government's analogy fails on every metric it invites the court to consider. So they just shut down the entire analogy that this just, a user of marijuana or any other drugs. Notice they said any, not just marijuana. Right? 922G3. Okay. And they just shot it all down. Taken cumulatively, these problems prove fatal to the government's prosecution of Mr. Hamani. The government's claim that historical laws targeted habitual drunkards for the same reason 922G3 targets unlawful users, because they regularly use intoxicants, is difficult to square with the historical record. Around the time of the founding and for decades following it, a habitual drunkard was generally someone who, for any considerable part of his time, was intoxicated. Now listen carefully. Not just intoxicated, but to such a degree as to deprive him of his ordinary reasoning faculties. In other words, he's no longer of sound mind. Okay? All right. So, a regular or even frequent drinker did not usually fit the bill. Many statutes define the term to require that someone drink to such excess that he was incapable of conducting his own affairs. Mentally incompetent, or had lost the power of self-control, like when they piss their pants. They pass out on the side of the road, in their chair, whatever. Okay. Okay, so let's see. The loss of the power of supplement. Given the culture of copious drinking in early America, historical laws targeted habitual drunkards not merely because they regularly used intoxicants, but because their drinking rendered them practically incapacitated and incapable of managing their affairs. By contrast, on the government's account, 922G3 automatically disarms anyone who regularly uses any amount of any controlled substance for anything other than its prescribed purpose, without requiring a showing that a particular individual is irregularly incapacitated, incapable of conducting his affairs, or a threat to himself or others. They failed to prove that. Okay. The government's claim that 922 blah 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 disarms unlawful drug users to protect the public from unusually dangerous individuals who will commit violent crimes, and that historical laws share a similar purpose, misapprehends the purpose animating those historical analogs. Vagrancy laws usually targeted those who did not meet the societal expectation of work and sought to promote productivity and suppress various vices, not to protect the public from a category of unusually dangerous persons. Civil commitment laws, by their own terms, generally did not seek to protect the public from violence so much as to protect habitual drunkards from themselves and to protect their families from financial devastation, like drinking them out of money. Okay? And the surety of good behavior laws the government invokes did not normally require a showing that an individual posed a threat of violence. Instead, they sought to protect the community from the scandals against good morals. Not from what I have found, even in my own Criminal Practice Act of 1864. It talks about the surety bond is to keep the peace, because there's supposed to be a level of a threats of violence or a fear of violence. Oh, imagine that. Okay, the way habitual drunkard statutes worked in the past differs significantly from how 922G3's unlawful user provision works today. The historical laws the government identifies usually provided some form of process before an individual lost any of his liberties, even temporarily. Wait, what? The historical laws the government identifies usually provided some form of process before an individual lost any of his liberties, even temporarily. Oh, you mean rights cannot be deprived except by and through the law of the land and a consent of a jury? Uh-oh. So what are they hitting on here, folks? That this violates due process of law. This is a bill of attainder. Oh yeah. Uh-oh. So now it's Telegram tonight. I updated my Streamlabs, my broadcasting software, before it went live tonight. And Rumble seems to be working okay, other than definitely not talking about some of the things that we were talking about last week, are we? And yeah, I see Telegram, quite a few people dropping off. I wonder if maybe people log out, come back in through Telegram, see if that changes anything. But yeah, let's hold on to this part right here. The historical laws the government identifies usually provided some form of process before an individual lost any of his liberties, even temporarily. A vagrant could be sent to a workhouse or jail generally only upon a conviction. Oh, you mean like the consent of a jury? A habitual drunkard could be assigned a guardian or committed to an asylum, usually only after proceedings before something like a probate court. Oh, would that be like those equity courts? Probate? Equity? Yeah. And surety statutes typically required a proceeding before a justice of the peace or a comparable officer before a bond could be ordered. Well, I'll be darned. They're sure laying this out pretty good, aren't they? for paying attention and reading it. By contrast, on the government's account, 922G3 automatically divests an individual of his constitutional right to bear arms the moment he becomes an unlawful user and until he ends his drug use, all without any pre-deprivation process. Yes, that's right, probate courts. That's your courts of equity. There's an equitable interest in a probate court. Imagine that. All right, number 4 here. There are reasons to doubt that the government has established 922G3 even serves the purpose the government claims of disarming categorically violent and unusually dangerous persons. Section 922G3's reliance on the Controlled Substance Act, a statute adopted to protect the health and general welfare of the American people, 21 U.S.C. Subsection 801.2, and under which drugs can be added to the schedules for reasons having little or nothing to do with their potential to induce violence, makes it far more obvious that 18 U.S.C. 922G3 confines its reach to those who are categorically and unusually dangerous. But see, the thing is under the Controlled Substance Act, if you actually go in under what that really is to regulate the health, yeah. What was the intent? Oh, for those acting in commerce. Oh, that's right. So, yeah, back up. Under which drugs can be added to schedules for reasons having little or nothing to do with their potential to induce violence. Makes it far from obvious that 18 U.S.C. 922G3 confines its reach to those who are categorically and unusually dangerous. Additionally, the government's own regulatory actions undercut its position. The Department of Justice has directed federal prosecutors to curtail enforcement efforts against marijuana users. Most states have legalized marijuana use to some degree, and the government recently moved some marijuana products from Schedule 1 to Schedule 3. But here again, the right of the people to be secure in their persons, papers, houses, and effects shall not be violated. What we have in our pockets, in our backyard, in our basement, in our attic, in our pockets, it doesn't matter. It's none of your damn business. That's not what we instituted government for. To dictate to us, the people, what we can frickin' have in our pocket. What we decide to put in our body goes back to the laws of nature. Our health is our business. It's our choice. Free will. God gave us free will. You want to smoke marijuana, you want to eat it, whatever, cook it, however that's all done, however you want to ingest it, that is your choice. The same as anything else. Whether it's alcohol, methamphetamine, cocaine, heroin, acid, mushrooms, it doesn't matter. It's your life, your choice, free will. We did not institute government to dictate to the people anything. Nothing. We never gave them authority to dictate to the people anything. But to the public servants. Now wait a minute. This brings up American jurisprudence. Where are you? I'm going to pull that up so we can all read it again. Where it says statutes are for government civil conduct. That's the internal policy, not internal police. Internal policy. American Jurisprudence, Volume 16, Constitutional Law, Section 2. This is Section 1. Section 2. And again, this is August of 2017 update. So this isn't old stuff. Distinction between constitutions and statutes. A constitution differs from a statute in that a statute ordinarily provides some details of the subject of which it treats. See, the Constitution delegates certain subject matter jurisdiction, whereas a constitution usually states broad general principles and builds the substantial foundation and general framework of the law and the government. You mean like the fundamental law? Yes, that's right. The Constitution is the framework of the government containing the general principles upon which the government must function, intended not merely to remedy existing conditions, but to govern future contingencies. Oh, like due process of law, because law of the land and due process of law are synonymous. It is a compilation of fundamental laws of the jurisdiction and embodies principles upon which the jurisdiction's government was founded. How many times have I talked about fundamental law out there? Remember the one guy that tried to tell me about fundamental law? And I asked him to cite it. And then he talked about territorial law. And I went to the Northwest Ordinance and proved him wrong. I also exposed him for the fraud that he was, because he never cited any law. He just ran his mouth and talked like he knew what he was talking about. But that's what a lot of them fraudsters do. They talk a good talk, but when it comes time to, as they like to call it, bring the receipts, they ain't got none. Like what am I showing you right now? American jurisprudence. We're reading directly from American jurisprudence. Are you really going to argue with me on this? Of what it says as it is written? This is the science behind the law, because that's what jurisprudence means. The science behind law. Juris, law. The science. So this is case law that has been considered as paramount. This is their evidence of the common law. But this is constitutional law. Okay. A constitution is made for the people and by the people, and is, above all, an embodiment of the will of the people, deriving its force directly from the people themselves. That is because all political power, policing powers, are inherent in the people. The people are the sovereign, not American state nationals. I'm throwing that in every time I talk about people. Okay? Now, what does it say? Statutes, by contrast, so in contrast to the Constitution, are enactments and rules for the government of civil conduct, promulgated by the legislative authority of a state. Instead of general principles, a statute provides details of the subject of the statute. By contrast, statutes are enactments and rules for the government of civil conduct, right? Mind control. Government, mind control. First, the Constitution controls their minds because the Constitution creates the president, the legislature, the executive, the judicial. That is the instrument of government that creates the government. It creates those persons. And any one of the people who are qualified, who are a qualified elector, who qualifies to be elected into those particular positions, have to act or perform the duties as we, the people, dictate. And for those other policies to regulate their civil conduct, control their mind, is statutes based on the subject matter jurisdiction, like, hey, a well-regulated militia being necessary for the security of a what? Free state, a state of being free. But it mentions the state. Oh, but the first 10 amendments don't apply to the states except for by and through the 14th Amendment. Hogwash. It's a Bill of Rights, and it's merely declaratory of the common law. All of those rights in the Bill of Rights are long antecedent in the formation of government. That's Hale versus Hinkle. Okay? Now, what does this say? Because constitutions constitute the supreme law, they preempt contrary statutes or rules and stand above legislative law. Thus, where a constitution speaks plainly on a particular matter, it must be given force and effect as the paramount law. And where a statute or other rule and a constitutional provision are in conflict, the constitutional provision must prevail. That is mandatory. It's called hierarchy. Which one stands on a higher plane? Now, there's one part here that sounds like a trick question. But which stands on a higher plane? The Constitution of a state or the laws of nature? If you said the laws of nature, you would be absolutely correct. Period. The laws of nature are at the root of all law. And as Blackstone enumerates or elucidates in his book 1 there, going over the laws of nature and those primary absolute rights, he makes the comment that any man-made law, wait, is the Constitution man-made? It's made by the people, so yeah, it's man-made law, that comes in conflict with the laws of nature is void for any effect. So, again, there is a hierarchy above the constitutions. The laws of nature are the highest law in the world. and it is applicable to the entire world, as Blackstone elucidates in his commentaries. In that same section where he talks about any man-made law that comes in conflict is void for any effect. But like it says, thus, where a constitution speaks plainly on a particular matter, it must be given the force effect of paramount law, and where a statute or other rule and a constitutional revision are in conflict, the constitution must prevail. It has been said that a constitution but a higher form of statutory law. Yeah, because it's still man-made law. But listen to what it says here. So that, for example, the state constitution is looked to where a court is searching for statutory law on a subject, and there is no relevant statute per se. In any event, both constitutional and statutory principles should be liberally construed to further the goal of allowing the people to express their will. No, it is to be narrowly construed in favor of the government and liberally construed in favor of the people. That's just, somebody threw that in there, was like, oh, well, you know, but the people say we can do this and this should be done liberally. No, narrowly. When it comes to the government, it's narrow. When it comes to the people, it's broad. Liberally construed in favor of the people. Always. Always construed in favor of the clearly and an intended beneficiary. That's how that's supposed to work. Okay? But the main part here I'm trying to point out is that they're looking to the Constitution for subject matter jurisdiction. Oh, no. Whoops. Right here. Unity of subject and title. This is our Idaho Constitution. Every act shall embrace but one subject and matters properly connected therewith, which subject shall be expressed in the title. But if any subject shall be embraced in an act which shall not be expressed in the title, such act shall be void, only as to so much thereof shall not be embraced in the title. Now, we have to go back to the Constitution and go, where do you have subject matter jurisdiction? Oh, look, it says gambling prohibited. There. Now the legislature can make legislation regarding gambling. Compensation of members. Oh, legislature can make legislation regarding that. Now, how about this promotion of temperance and morality? How about, oh, wait. Power and authority over intoxicating liquors. Okay, where does it say power and authority over controlled substances? Where does it say that? Where does it say power and authority over marijuana? Well, you know, certain states have legalized it. No, you have no legislative authority. This is how we delegate power and authority, by and through the Constitution. So, like Chris used to say, or we used to say, is, can you point to that emolument and grunt? Huh. Continuity of state and local government operation. There's legislative authority. Now, before I go back to promotion of temperance and morality, I'm going to go into this marriage. And a woman is the only domestic legal union that shall be valid or recognized in this state. The federal national government legislature has no authority to say, oh, no, gay marriage is legal. No, it is not. Because we, the people, said, no, marriage comes from God, is a sacred vow between a man and a woman till death do them part. Well, I should say, unto God till death do them part, not unto the state, which is what they've done. They've converted this right into a privilege, licensed it, and attached fees to it. But, wait a minute. What's this? Promotion of temperance and morality? The first concern of all good government is the virtue and sobriety of the people. What? Virtue and sobriety of the people and the purity of the home. The legislature should further all wise and well-directed efforts for the promotion of temperance and morality. You mean those in government must exhibit virtue and sobriety, morals and principles? For those of you that might remember when I was reading Montesquieu and his Spirit of Laws? And how he talked about it doesn't matter what form of government you have other than the despotic government. But if you do not have virtue or a virtuous government, you have a despotic government. It doesn't matter if it's a monarchy. It doesn't matter if it's a republic that's either a democracy, an aristocracy, or a confederacy. It doesn't matter if you're without virtue. But let me go further, because this right here would shut down pride, the gay pride stuff, Pride Month. All of the government buildings putting up pride flags. Is that not in direct violation of the Idaho Constitution? If you're not quite convinced yet here, you might be after this. If not, you're not of sound mind. You should be locked in an insane asylum. Because I'm going to show you where it actually says that. Now, when we talk about guarantee of religious liberty, it's not exactly what everybody thinks it actually means. This is your liberty of conscience, free will. That's what religious liberty is. Free will. The exercise and enjoyment of... Let me make this bigger so people really can see that. The exercise and enjoyment of religious faith and worship shall forever be guaranteed. And no person shall be denied any civil or political right, privilege, or capacity on account of his religious opinions. What about natural? What about natural rights? Like this one. But the liberty of conscience hereby secured. Where? Where did it mention liberty of conscience that's hereby secured? would that be the exercise and enjoyment of religious faith and worship? Is that the liberty of conscience hereby secured? Where? See what I'm saying? But we go back to Blackstone in his commentaries, and before the three primary absolute rights, personal security, personal liberty, and private property, he talks about free will and the liberty of conscience. But let's continue reading what it reads in the Declaration of Rights. And yes, any and all, everybody else can cite this particular, because this is a Declaration of Rights. Shall not be construed to dispense with oaths or affirmations, or excuse acts of licentiousness, or justify what? Polygamous or other pernicious practices. Oh, you mean like homosexuality? Transgenderism? Is that a pernicious practice? Absolutely. Because what's the next part say? Inconsistent with morality or the peace or safety of the state. Boy, you want to talk about somebody who uses any kind of drug out there, you automatically lose your gun rights because, well, you're a threat to the security and safety of the people. Well, what do you think this crap is with the gay pride crap? Transgenderism. Back to one of the laws of nature is man shall not mutilate himself. That's right. I think that is inconsistent with morality. And it sure is disturbing the peace. And man, have you ever tried to have a conversation with some of these people? Our safety is in jeopardy because they get pretty freaking nasty sometimes. Because they're messed up in the head. They should be locked up in insane asylums. Now I'm going to clarify something. Fourth Amendment. The right of the people to be secure in their persons, papers, houses, and effects. Okay. If you want to be a homosexual, keep it in the privacy of your own home. You're safe there. I'm not saying I'm not against homosexuals and all that stuff. Morally, it is wrong. That's my religious belief from the Bible, because God tells us, man shall not lay with man. He abhors homosexuality. He didn't create us naturally to be that way. It's called the attraction of the sexes. Oh, the sexes, not genders. And for those out there that want to talk about the word gender, you might want to go down the rabbit hole and look up etymology on the origin of the word gender, because they started using the word gender because sex took on like a taboo thing. Yeah. But there are only two sexes. Therefore, there are only two genders. I could give a rat's ass about any so-called, but the science. God created man, and man with a womb. That's what a womb man is. A man with a womb. So you're either a man, or you're a man with a womb. And generally speaking, man has a penis, and women have a vagina. Even a hermaphrodite still has a womb. It might be a strange anomaly. Yes, it happens. All right. Back to the law here. Right, says the law. Nor to permit any person, organization, or association to directly or indirectly aid or abet, counsel, or advise any person to commit the crime of bigamy or polygamy or any other crime. If it's inconsistent with morality, that's a crime. I mean, we're talking about the crime of bigamy or polygamy or other pernicious practices. I'm going to look over some comments here before I get back to the case. Yeah. How's it working over here on Telegram? Any better? Actually, I'm seeing quite a few people dropped out, so man, if it isn't one thing, it's another, eh? Last week it was Rumble. This week Rumble seems to be working just fine, but Telegram isn't. Now, pay attention right here in our Declaration of Rights. Bigamy and polygamy are forever prohibited in the state, and the legislature shall provide by law for the punishment of such crimes. That is a delegation of legislative authority. Imagine that. So now back over to the case. Talking about different classes of people. And again, where is their legislative authority to enact the Controlled Substance Act? Remember, the law is supposed to apply equally to all. So if we, the people, per se, that it's unlawful for us to possess and consume this stuff, then it is also unlawful for any corporation, organization, pharmaceutical drug industry. It should be unlawful and illegal for them to possess it, to manufacture it. Right? But given that cannabis, not marijuana, is naturally occurring, God created it. Not only that, God gave us a cannabinoid system in our bodies to process THC and more specifically like CBD, which is extremely beneficial for us. Has all sorts of healing stuff, which is what Trump, I believe, just found out, which is why he moved it from a Schedule 1 to a Schedule 3 and deregulated it and said, hey, pharmaceutical industry, medical industry, right, are going to do the research on the benefits of cannabis. Yeah. All right, let's read some more here. Which drugs can be added to the schedules, blah, 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 blah. We just moved to Schedule 3. Affording the government broad power to designate any group as dangerous and thereby disqualifying its members from having a gun. would risk allowing it to quickly swallow the Second Amendment. Listen to what they're saying here. Are you picking up what they're laying down? The court's decision is narrow. It does not address efforts to ban addicts or those presently intoxicated from possessing a firearm. Other prophylactic laws, prophylactic laws, what a choice of word there, Congress might adopt after determining that users of a particular drug pose a special risk of misusing firearms. 922G1's provision disarming individuals convicted of felonies, or whether the government could bring a prosecution under 922G3 accompanied by individualized proof that the defendant's drug use renders him a danger to himself or others, or proof that a certain drug always renders its user dangerous. Affirmed. Yeah. So maybe they didn't do this over here about being convicted of a felony. But I thought that was in part done by New York State Rifle Pistol Association versus Bruin, as well as the Rahimi case. But I also recently heard that there was another case, and I haven't seen that one yet. I need to do a little more research and see if there was another case that they just ruled on, or if it's a case that's in a circuit court and hasn't made it to the Supreme Court yet. So maybe. Oh, absolutely. A Munson 58. I am a big proponent of hemp for everything. We can make cars. Hemp can actually be processed to the point where it's stronger than carbon fiber. Right? Like you're talking about. Hempcrete blocks for building materials. Absolutely. The whole textile industry. Fabric. Like soft as cotton. Like Levi's used to be made out of. Like rope used to be made out of. Right, Jacqueline? Part of some of the marijuana stuff, they wanted people to smoke marijuana so that they could take away our right to keep and bear arms. And that's exactly what they're exposing here in this case. But when you get down into here, if you want to fully read all this stuff, it gets into talking about, see, that was just the syllabus. Okay? The extremely short version. But when you get down into here, what's it talk about? It doesn't have anything to do with commerce. What? Why did they bring that up? Because Congress adopted 922G pursuant to the Commerce Clause. Uh-oh. Under the Constitution, the powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. Marbury versus Madison, 18. Oh, that's 1 Cranch 137. It's not 5 USC. It has now been 26 years since a party has received relief in this court based on a Commerce Clause challenge. Such relief has also been hard to come by in the lower courts, as the decisions concerning 922G as a whole show. This question merits a closer look in an appropriate case. For like Judge Batchelder, I am unprepared to reduce the Supreme Court's Lopez decision to an anachronism to be noted in passing but ignored. Congress's enumerated powers, like Supreme Court opinions setting forth their limits, are in my view to be taken seriously. Why would there be Supreme Court opinions setting forth their limits? Doesn't the Constitution itself set forth those limits itself? What do we need the judicial branch for? They're just like the rest of the branches. They're bound to support it. Why are they think that they have the right to empower to interpret the Constitution? It's the supreme written will of the people. It is paramount. How then can a public servant who is bound to support it interpret it? Just blows my frickin' mind. Oh, I better go back down here. Yeah, what are they saying here? Oh, you know what? I'm going the wrong way. That's why. Let's start back up here. The statute requires the government to show that a firearm possessed in violation of the statute's terms has been shipped or transported in interstate or foreign commerce. As that element is not in dispute here, we do not discuss it further. That's because Mr. Hamani didn't bring that up. But here we are. They bring it up, and they do it in every other frickin' case, right? When they want to use it against us, they bring up stuff that wasn't in the record before. They do it all the time. What does this say? I write separately, okay, Justice Thomas concurring. I agree with the court that 922G3 violates the Second Amendment as applied to respondent Ali Hamani, and I join its opinion in full. I write separately to call attention to another issue. As a matter of both original meaning and this court's precedents, 922G3 appears to exceed Congress's enumerated power to regulate interstate commerce. The statute makes it a federal crime for an unlawful drug user to possess any firearm or ammunition in or affecting commerce. A conviction for unlawful firearm possession if the firearm possessed by the drug user had previously traveled in interstate commerce. The Commerce Clause did not authorize Congress to regulate or ban possession of any item that has ever been offered for sale across state lines. Such as an understanding would convert congressional authority under the Commerce Clause to a general policy power of the sort retained by the states. But even the states don't have it either, because the Commerce Clause does leave it to Congress to regulate foreign and interstate commerce. So while the issue was not presented in this case, the court and lower courts should revisit the constitutionality of 922G as a whole, not just G3. So this is what blows my mind. Is like we get here, and it takes years to get here, and they really want to narrow it down and diminish it, and make it harder for us. We have to pick it one little thing at a time. This is why I'm saying we need to go after the root problem. One, the code is Roman civil law. That is a jurisdiction foreign to our Constitution, unacknowledged by our law, and given his assent to their pretended acts of legislation. It is a foreign jurisdiction. We are supposed to have common law as our fundamental law. And yes, a statute would be based on the subject matter jurisdiction delegated in the Constitution, just like what they're talking about here. All right. Yeah. If we got rid of the entire code, which would include 18 U.S.C. 922G, because it's not a legitimate statute. And you cannot make a crime through legislation. You cannot say, oh, we're creating this statute for, but see, again, unity of subject and title. They would first have to create, say, the Food and Drug Administration or the Department of Health and Welfare, wherever they think they're going to put this under, and they would have to create the statute under that, which creates that, which they don't have the authority to create those anyway. So there's another root problem. Where in the hell in the Constitution did we, the people, delegate the power to create all these executive departments? Oh, that's all that Administrative Procedures Act, which goes back to, again, creating a monarchy where corporations, that's how a monarchy operates, is with corporations posing as government. You know, like the first charter of Virginia, corporate charter, the Virginia Company, the East India Company, the West India Company, the Hudson's Bay Company, the New England, whatever company that was. There were several companies that were created by the Crown to come over here, right? That's how that went. Oh boy. Weird noises. Connection's bad on Telegram tonight. Wow. Sorry, guys and gals. Section 922G criminalizes intra-state gun possession. Oh, yeah. Telegram just basically just crashed for me, too, now. And that's crazy because I actually just recently rebooted my modem. What? 2 nights ago? So, yeah, sorry folks, over here on Telegram. Get reconnected for you, but Sorry, over here on Telegram, folks, it reconnected for you guys. Reconnected for me. But it's not showing. There we go. Crazy. Dang this stuff. Technology. Somebody's messing with it. Gotta be. Everything else is working great tonight. Facebook, YouTube, Rumble. Not Telegram. And I don't see where it says I need to update Telegram. That'll probably come out after we're done. Who knows? I don't know. Do I have updates to Windows? Of course, I can't see while I'm screen sharing over here, but funny noises over on Facebook too. Wow. So let's just go ahead and pull that up. Now, unity of subject and title here, right? Crimes, firearms. Where do they have subject matter jurisdiction over firearms? Well, let's look at what a definition is here. The term person and the term whoever include any individual, corporation, company, association, firm, partnership, society, or joint stock company. Where does it say man or the people? Inhabitant. Citizen. Do we see a problem here? There's no personal jurisdiction. Uh-oh, what again? The term interstate or foreign commerce includes commerce between any place in a state and any place outside of that state, or with any possession of the United States, not including the Canal Zone or District of Columbia, but such term does not include commerce between places within the same state, but through any place outside of that state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States, not including the Canal Zone. Well, that doesn't mean the United States. Oh, but that would be that United States. The term firearm means any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, or any destructive device. Such term does not include an antique firearm. Wow. Oh, so poisonous gas, that's considered a firearm? Any type of weapon other than a shotgun or a shotgun shell, which the Attorney General finds is generally recognized as particularly suitable for sporting purposes. Okay, so shotguns are not considered firearms. And why does it have anything to do with the Attorney General? Term shotgun means a weapon designed or redesigned, made or remade or intended to be fired from the shoulder and designed or redesigned and remade to use the energy of an explosive to fire through a smooth bore, either a number of ball shot or a single projectile for each single pull of the trigger. Jeez. I don't see pistol any yet. Hold on. Oop, there's handgun. Oh, the term engaged in the business means crap. Well, let's look at that real quick. Let's go back to the 9. What was it? 9. $9.28, right? No, $9.22. Unlawful acts. It shall be unlawful for any person. Doesn't say people, didn't say man, except a licensed importer, blah, 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 licensed dealer, to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce. Oh, well, let's go down to the G, because that's where we need to be, really. It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So, a felony. Who is a fugitive from justice, who is an unlawful user of or addicted to any controlled substance as defined in Section 102 of the Controlled Substance Act. There it is, 21 U.S.C. 802. Who has been adjudicated as a mental defective or who has been committed to a mental institution. Who being an alien. Who has been discharged from the armed forces under dishonorable conditions. No. You cannot take that right away. Comes from nature. Who, having been a citizen of the United States, has renounced his citizenship. Uh-oh. You mean all them American state nationals? I mean, isn't that what they're saying? That they're renouncing their citizenship? Now, here we go. Who is subject to a court order that was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate. I'm just curious. How does a corporation own a gun? Own a firearm? Own arms? How does a fiction, technically speaking, how does a fiction own anything? Because a fiction can't think, it can't talk, can't walk, it can't get up on the stand and be sworn in and testify to anything. Right? So, how is that possible? It always takes a man to do something. Yeah. Hmm. I mean, basically, this whole thing just needs to be wiped. You have no legislative authority. The right of the people to keep and bear arms shall not be infringed. And I'll tell you right now, folks, I found it in my Idaho Criminal Practice Act of 1864. The very beginning, the second thing the legislature created in Idaho, it says, when you're done with your sentence, your time in jail, whatever, you get all of your rights back. All of them. It doesn't say, well, except your right to keep and bear arms. So how about that? History and tradition and the rule of the common law. All right, folks. Much love to everybody out there. Thank you all for being here and sticking through it over there on Telegram tonight. But I did want to make the announcement. I'm sorry, folks. I am going out of town, going camping Tuesday through Friday, so I apologize for no Wednesday night workshop. I apologize for last week. We had Mom's trial on the trust case, and it was all day. I was up at frickin' 6:15 in the morning, putting together some late stuff there, and down at the courthouse by 8:15. And we didn't get out of there till 4:30. Done with the trial at 4:30. Yeah, by the time I got home with the 5 o'clock rush hour traffic, sitting here, it was like 6 o'clock, and all of a sudden I finally looked at my phone, but Mom and I were sitting here talking about what was going on and what happened there. And anyways, I was like, oh crap. A couple of people hit me up, Wendy, Jax. Hey, what's going on with your class tonight? Oh crap. So I apologize for that. And man, I need a break. I need to go get some get away, get some mountain time, go ride the dirt bike, and get away. I need some downtime. All right, folks. So no Wednesday night workshop this week. But the next one we do have, I'm telling you, folks, there's some things that we need to discuss. And we need to start bringing the people together and start doing these public corruption complaints. And a little more on the FMCSA. All right. So God bless everybody out there. I miss y'all on Wednesday nights. So don't think I'm not missing y'all over there either. But I need a break. So God bless you and everyone else there. Much love, and we'll see you next Monday. All right.